Okay, welcome to Chapter 1. We're going to be talking tonight about the law and legal reasoning. This is, again, our first lecture for business law, so we're going to try to take some of your text and maybe focus it a little bit more on the specifics of business law and perhaps stay away some of the theoretical that it tends to go into. Okay, so the first thing to talk about is, of course, that business has an impact on the law, but the law also shapes business. So this first slide lists all the different areas, and there are more than just this, where the law touches business. And many of these really are groupings inside our textbook of things we'll talk about. Certainly contracts is one of the major units we'll look at. We'll talk about sales, negotiable instruments, creditors' rights, intellectual property, e-commerce, product liability, torts, agency, business organizations, professional liability, courts and procedure. And of course, it's not just those. There are others we could talk about. For example, the criminal law also touches business, and that is obviously part of the law as well. So that's not an exclusive list. There's more that we could add to that. Quick example here, and of course this is a relatively recent, and I know 2014 since it's 2020, almost 2021 now. 2014 doesn't seem recent, but trust me, in the law, anything less than probably 20 years is recent for us. So in 2014, the Supreme Court of the United States was reviewing the Affordable Care Act, and I believe the vote was 5-4. The Supreme Court upheld that the Affordable Care Act was constitutional. Now, since then, since 2014, there's been another case which struck down at least part of the mandates. That has really impacted the whole other issues about it, and as I record this lecture in October of 2020, the Supreme Court is getting ready to again hear a case about the Affordable Care Act, and I think it's entirely possible that it could strike it down, particularly given the changes in the court. The Supreme Court had also ruled, and this would be the Citizens United case, again this would predate 2014, it's a little bit earlier, that corporations are free to make political contributions. Also, some legal issues affecting the growth of Facebook. The idea that as a platform, unlike a newspaper which publishes something, Facebook and some of these online sites don't have the same liability. Okay, we want to also approach the idea of ethics and morality and kind of its poor step cousin, legality. Morality is determining right from wrong. Ethics is the practical application of what is right and wrong. Now, where legality comes in is that it's fair to say that there is a relationship between what is legal and what is ethical, but it is not necessarily an absolute relationship. It is legal to do certain things which are clearly unethical. For example, it's legal to lie. If your lie doesn't have a direct harm, which would perhaps be actionable as a tort, if you lied to someone about were you going to pay them for something, could be breach of contract. But if you just tell a lie to someone, oh, I really like your dress, or I really will support you if something happens. Well, that type of lie is unethical, but not illegal. So sometimes we call this the legal minimum. The legal minimum is not what is the moral or ethical minimum. And we have to ask ourselves how much of ethics, how much of morality is present in business and in the law. So where does the law come from? Well, we sometimes say that there are tiers of law. And at the absolute highest tier is constitutional law. And this is the ultimate law in the United States. If something directly contradicts the Constitution, it'll get struck down. Now, the bare text of the Constitution before the amendments to the Constitution, and there's been a few dozen or so, was created in the 1780s. So you have Article 1, Article 2, Article 3, that's the important 3 articles, there's some in 4, but set up the American government and really talk about certain, with the first 10 amendments in particular, talk about certain fundamental rights. If anything conflicts with the Constitution, it loses. Now, of course, what is written in the Constitution is subject to interpretation, and judges interpret. I was just reading a case tonight where the Alabama government had banned curbside voting, and it went to the Supreme Court of the United States, and 3 of the justices, the liberal justices, said, well, you know, this is a health and safety issue, and the state of Alabama can't demonstrate any reason, per se, why they should not have curbside voting, except they don't want it. And it's clearly going to disenfranchise a group of people, make it dangerous for them to vote. And we find that would be an unconstitutional deprivation of due process. But the majority of the court said, nope, the way we read the Constitution, Alabama can go ahead and ban curbside and assisted voting. Okay, down from constitutional law, you have statutory law. This is law that is passed by the general legislatures of the state or by the Congress of the United States. So, you know, for example, and sometimes it's in the same field, you have the Environmental Protection Agency, which was created by the federal government. But then you also have, in every state, South Carolina, Montana, you're going to have their own Environmental Protection Agency. They might call it something different. Also, the federal government is going to define, say, murder. It's going to define what is and isn't homicide. And the states will define it. After administrative law, which is law that's passed by the legislatures, and that's really a small amount of law anymore, to be honest about it, is we get to administrative law. Now, administrative law, I just mentioned the IRS. The IRS writes rules, agency rules. These rules have the effect of law. If you don't follow IRS regulations, you can be arrested, you can be tried, you can be convicted, you can be sentenced, all from something that was created by an administrative agency. So there's really 2 types of agencies: executive agencies, agencies that are essentially under the direct control of either the president, if it's a federal agency, the IRS is one of these, or the governor. For example, the North Carolina Department of Revenue is an executive agency, at least in part. Then you have independent agencies. These are agencies that exist outside the direct control of the executive. The Federal Reserve would be a good example of this. You will hear the term uniform law, and it's very common that in the United States, the American Bar Association and or business groups will get together and try to create a standardized body of law across the United States and then get each state to adopt it. And why would they do that? Because if you've got a big business like Apple or Amazon, it's going to be much easier for you, much better for you, if you can create the same law in each state, and that way you don't have to tailor your businesses and your behavior differently in each state or have different expectations. So the biggest example of this is the Uniform Commercial Code, the UCC, and you're going to get sick about hearing about the UCC. But there was something called the National Sales Act, and there was some attempts really to frame it and create it earlier than this. But it was created to create a standardized body of commercial law in the United States, and every state has adopted it. Okay, you're going to hear the term common law. The common law is basically a creation of the English-speaking world. It starts in England in the Middle Ages. It starts in the courts, somewhat in the not so much the legislature, but basically in an era where most people couldn't read or write. So it didn't do you a lot of good to enact laws. Say, okay, we've got a law down in London we passed. Well, you know, I live up in York and I can't read and write. So what good does you writing down a law in London do? So the common law develops. Much of it isn't written down, and it comes over to America. And a lot of it is based on the idea that there ultimately developed two separate types of courts: courts of equity and courts of law. So courts of law were based on statutes that were passed. They tend to be very technical. Courts of equity were based on the idea of fairness, and there's always a struggle in the law between following the letter of the law and then doing what is fair or just. And that tension has existed since the law was created and will exist long after we're gone. Today, we don't have separate courts. In the past, we actually had separate courts you would argue in. In equity, okay, in equity courts, when you looked for, well, what's fair, it was often legal maxims that would point you in that direction. For example, if you seek equity, do equity. So if you're asking to be treated fairly, you better have treated the other person fairly. If there's a conflict between what you think is equity and what the law clearly says, then the law is going to win. Equity really is going to be one of those fill in the blanks. So there's a gap here, and we're going to use fairness to figure it out. There should be no wrong without a remedy. Substance is more important than form, and equity supports vigilance, not sloth. All of those are things that were applied. The other big thing that comes out of the common law is the doctrine of stare decisis. And I know it's spelled weird, but it's stare, which most English speakers would say stare. And it actually should be decisis, but we pronounce it decisis, D-E-C-I-S-I-S. It literally translates from the Latin as let the decision stand. And what it means is that, let's suppose that 40 years in the past, there was an apple tree that was growing over onto a neighbor's land, and the apples fell from the apple tree and landed on the neighbor's land. The owner of the apple tree said, those are my apples just because they fell on your land. It was from my tree. The tree's growing on my land, just so happens some of the branches. The other landholder said, no, they're mine. So they go to court, and the court decides, nope, wherever the apples land, whoever land they land on, it's their apple. Fast forward 40 years, another apple tree, or let's suppose it's not quite an apple tree, let's suppose it's a pear tree or a peach or an orange tree. Same situation. It grows, some of the branches go onto my property, some of the oranges fall onto my land. Who do they belong to? Well, under the doctrine of stare decisis, we would take this old precedent, is what it's called, this old case, and we would apply it. And we would say, okay, it's pretty similar, so we're going to apply it in this case. Now, if it's not exactly the same, or if it's from a lower court or an outside court, we might say it's persuasive but not controlling. Now, sometimes you've got precedent in the past that's very good. Sometimes, however, there's changes in society, there's changes in technology. Sometimes you're going to have a case with no precedent. You know, one of the reasons I think we're struggling with the idea of abortion in the United States and across the world in many ways is that this is a technological and a societal change combined. It was until really the 19th to 20th century, there were no safe ways, reliable ways to induce an abortion. It's only when technology changes that we say, okay, now we're going to have to deal with it. Same thing with, say, something more extreme like cloning. Well, there's no laws about cloning in the 1800s and 1900s because no one could clone. So if there's no precedent, the court will look at different things. What are the legal principles and policies? What's public policy? What's fair? What are the social goals? What are customs? Sometimes, though, we have precedent in the past and we say it's bad. So let's talk about one precedent was established. In the 1800s, after the American Civil War, a individual got on a train in Louisiana, and he had bought a first-class ticket, and he tried to sit in the first-class car. Unfortunately, he was black. So I don't mean that unfortunately for him, but unfortunately for the law here, he was denied a seat, and he sued, and it went up to the Supreme Court of the United States. The Supreme Court of the United States said, well, you know, we're going to establish the precedent that so long as there are equal facilities, they can be separate. So they said separate but equal is okay. And now, for the next 60 years in the United States, till late 1950s, early 1960s, like I said, Plessy was after the Civil War, 1880s, 1870s. For that period of time, separate but equal was law of the land. But eventually the court looked and said, yeah, we have this precedent in the back, and stare decisis should be taken into account, but it's bad law, so we're going to overturn it. And in Brown versus Board of Education, the Supreme Court struck down all this past precedent. More recent example in our lifetime, we have Lawrence v. Texas. Prior to Lawrence v. Texas, homosexuality was a criminal activity in many states in the United States, including North Carolina. After Lawrence v. Texas, it could not by itself be illegal. Of course, then there was another struggle. We got the Obergefell case about gay marriage. But you can see how you have rules in the past. Usually we uphold them, but sometimes we change them. One of the things you have to realize is there's very rarely just one right answer. One case where we say, okay, this is absolutely it. Because those cases either don't get to court, or they're decided very quickly at a lower court and nobody appeals them because the answer is obvious. It's only when you've got a real conflict between competing issues of rights, the law, social factors, fairness, that you have these major cases. So going back to abortion, you know, the conflict in abortion is between a number of powerful factors. What about the right of the fetus or the infant? What about the right of the woman? So they're in conflict with each other. What does the law have to say? What does fairness have to say? What does society have to say? And you also have to realize that no decision is made in a vacuum. Decisions are influenced by politics. Decisions are influenced by the personalities of the judges. All judges and all laws have some bias built into them, whether they want to admit it or not. No one is completely neutral, completely rational. One of the cases I like to bring up as kind of a quickie analysis here is the McDonald's coffee case. And if you'll recall this case, it's somewhat notorious. You hear people who want tort reform talk about this quite a bit. They'll say, oh, this is a crazy case. Mrs. Liebeck, who's this old woman, went into McDonald's, spilled hot coffee on herself, sued McDonald's, won $2.68 million. And this looks to be crazy. But what they don't tell you is that she had initially offered to settle for $20,000, and McDonald's had several options to settle but didn't. So here are some of the facts of the case. McDonald's was serving its coffee at between 180 and 190 degrees, which is incredibly hot. It was much hotter than other fast foods. And that will produce a third-degree burn as quickly as 2 to 7 seconds or as long as 12 to 15. Very rapid. And in the 10 years of the records that the plaintiff's attorneys could get between 1982 and 1992, 700 people were fairly badly burned by McDonald's. Now, Liebeck's attorney argued that this was a dangerous thing. To be brewing coffee this hot was grossly negligent. And the clear reason they were doing it was just more profitable. Now, why don't you just change the law? Well, if you're Mrs. Liebeck and you say, I want to go to my state and have them change the law of coffee brewing. Well, first of all, if McDonald's wants to fight you, Mrs. Liebeck, they're a big corporation. You're not going to get changed. The law is in many ways a mechanism to allow people to affect change in society. And so long as it's present, it lets the little guy, the Mrs. Liebecks of the world, really have their say. And it's one of the leveling of the playing fields. Now, ultimately, in this case, the case was settled for $600,000, and McDonald's started brewing its coffee cooler, not as hot, and stopped scalding people. So it was a win for everybody except McDonald's. Okay, we can talk a little bit about the different schools of jurisprudential thought. I'm not going to go into these very much, but these are different approaches. One of the ones that's very close to early American thinking is called the natural law school. This believes that there is a law outside of man. So you can discover this, and the famous, we hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain inalienable rights. That's saying, okay, there are rights out there that you can discover, they're self-evident, and they can't be traded away. Now the positivist said, well, the law exists and is fixed by what society today says the law is. There's no external right or wrong. It's constantly changing. And that plays with a little bit the historical school, which says the law is a product of the past, and somewhat with legal realism that says the law arises from and in turn is shaped by and shapes society. Okay, some other different classifications of the law. We have substantive law, which asks the question, is the law fair? So sometimes you'll hear the term substantive due process. Is the law fair? So if you had a law that said we're going to execute people for jaywalking, you would say, well, that's not a fair law. That's a violation of substantive due process. Then we can classify law as procedural. And again, that we would say procedural due process. Now that might be something that seems reasonable. Let's suppose we had the death penalty for people that committed murder. But suppose I could show you that the only people ever executed were, let's make up a group, albino, New Guinea, Catholic, one-legged, one-eyed, blonde women. And those were the only people ever executed. Of the 20 executions in the United States, all of them were in that group. They all had about all those characteristics. Well, the law may be seemingly neutral, but if you're targeting just one group with it, you would say that its application is unfair. Okay. Civil and criminal. Civil regulates the dispute between two individuals. Criminal are wrongs committed either against an individual or society as a whole, and they're prosecuted by the state. You also have cyber law there. So where do we find law? Well, assuming we're not going to talk about constitutional law, I'm going to assume you can all look up Constitution. We have to start with statutory law. Statutory law is, as I said, passed by the North Carolina General Assembly or the U.S. Congress, or whichever state you're in. So if we looked at the criminal law in North Carolina, you're going to find that in volume, sometimes chapter, it's called in different states, volume 14 of the North Carolina General Statutes, section 104. Federally, we don't call them volume or chapter, we call them title. So if you're looking for a particular title, it would be Title 15, USC, US Code, and then section 101. Administrative law is all published in the Federal Registry, which comes out every day of the year, and there's a copy of it available. All right, case law. What's case law? Well, I'd mentioned Plessy versus Ferguson was a case. I mentioned Lawrence v. Texas was a case. But what do those terms mean? Well, let's take an imaginary one. Jones versus Smith. In this one, Jones v. Smith means Jones sued Smith. The case was heard in 1987 in the North Carolina Supreme Court. It was reported in the North Carolina Supreme Court reports. It will be found in volume 113, and it will start on page 107. Anytime you see the abbreviation of a state, NY, CA, AL, that means that's going to be that state Supreme Court. If you see just US, it means the US Supreme Court. So how do we read and understand these cases? Well, as I said, there's two, State versus Jones, Smith versus Jones. If you see the state's name, it is often but not necessarily a criminal case. So if you saw North Carolina versus Jones, although here we tend to use State v. Jones. An appellant is the person who appeals a case. That's the one who lost. The appellee, that's the one who won in the lower court. He's having the case appealed against him. What you read, every decision you've ever read, like State versus Jones or Plessy versus Ferguson or Brown versus Board of Education, is called an opinion. It is the written explanation of the court as to why they ruled. Now, if all the judges agree for the same reason, which was the case in Brown versus Board of Education, they issue what is called a unanimous decision. If judges agree, but for different reasons, we call it a concurring opinion. If judges disagree, for example, that case about voting in Alabama I mentioned, three of the judges, Sotomayor, Kagan, Beyer, all disagreed with the court. So they wrote dissenting opinions. They said, we understand what the decision of the court is, this is why it's wrong. Okay, it's about a half an hour. That's about how long I like to make these or so. And we'll go on to chapter 2, and you can listen to that whenever you're ready.